Right from the start, this is a serious felony sentencing hearing. The defendant has already pleaded guilty, which means today's moment isn't about whether he committed the crime. It's about how much time he'll pay for it. And as you'll see, the judge already has a mountain of background information before making this decision.
We're here in the case of State of Ohio versus Justin Dam, case number 25 CR 1480. Defendant is present and represented by defense counsel Rachel Smith. Defendant has previously pled guilty to burglary, a felony of the 3rd degree, and possession of cocaine, a felony of the 5th degree with the forfeiture specification. Since then, a pre-sentence report and drug and alcohol evaluation, as well as an opportunity for a victim impact statement has taken place. We're here today for the sentencing.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you want to say on behalf of your...
This is the defense's big strategy: community control, which is essentially probation instead of prison. It usually comes with strict conditions like drug treatment, supervision, and regular testing. But here's the key question. Does this defendant have a history that shows he can actually follow those rules? Keep that in mind as the story unfolds.
Client.
Yes, Your Honor. On behalf of Mr. Dam, we are asking the court to impose a period of community control. Your Honor, Mr. Dam has an extensive history, but from the beginning of this case, he's indicated that at this point in his life, he is trying genuinely to change in a manner that he has not in the past. Your Honor, prior to the instant offense, Mr. Dam had been released from prison back in May, had maintained 5 months of sobriety, was employed. He then lost his housing, ended up relapsing, and then committed the acts that bring us to court here today. Mr. Dam understands that his criminal conduct is a direct result of his drug use and that he needs to address both. Mr. Dam has never been on probation as an adult, and he's 29 years old. He's single, he has no kids. He's asking the court, despite how things look on paper, to give him one opportunity as an adult on community control so that he can pursue a treatment path and address the myriad of issues that bring him in front of this court today.
Thank you. Mr. Dam, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Yes, sir.
Good.
This is the defendant's allocution, the moment when the person facing sentencing speaks directly to the judge. In many cases, this is the last opportunity to show remorse and convince the court that prison isn't the only option. But judges hear apologies like this every single day. The real question is, will this one feel different?
I know I've been in front of you multiple times, and I can't sit here and act like I didn't do what I did, because I did, and I'm trying to take full accountability of it. As I've gotten older, been to prison, I haven't learned anything from there. I just want a chance to do what's right for myself. My head space is different this time because I actually want it. I've actually been trying to put the work into doing it. Even though I did slip up and do what I did, I regret it. I tell my mom every day how much I regret doing what I did. I don't want to be here in front of you right now and saying what I'm saying, but I'm taking accountability for it, and I just want the chance to try to do the right things and prove to people that I can do the right things. Since I got bonded out a couple months ago, I've done everything my attorney has asked for, everything the court has asked for. Clean urines, going to all of my appointments, keeping in contact with everybody I'm supposed to. And I want to do the right thing. I don't want to keep coming in front of you. I don't want to ever come in front of you again. I don't want to be in this situation ever again. And I'm tired of it. And I just want to do the right thing. And prison isn't helping me. And I know that I don't need to commit a crime to get help. But I'm just asking you to please just give me this chance. And if I fuck up, or if I mess up, I'm sorry. If I mess up, then I know what happens. I just really want this chance. And I please hope you can consider that.
Thank you.
And sorry for my language.
Ms. Smith, anything else?
Not at this time, Your Honor.
On behalf of the state, Mr. Gritsky?
And now the tone of the courtroom shifts dramatically. The prosecution is about to lay out the defendant's full criminal history, and this is where sentencing hearings often turn. Because when judges hear a long pattern of repeated offenses, it becomes much harder to justify another chance.
Your Honor, the state recommends prison. In this case, the facts have been outlined, and change of plea hearing are also in the pre-sentence report. The victim, the defendant's father, is the victim of this, or stepfather, excuse me, is the victim in this case. State feels prison is appropriate because of the defendant's exceptionally long criminal history. For that, a long history of juvenile adjudications where there were failures to rehabilitate, and then his history, criminal history, at least with felonies as an adult, started with a burglary conviction for which he went to prison for in 2017. It was a theft conviction for which he also went to prison for in 2017. Shortly after he was released, he was convicted or committed another burglary. He was convicted and went to prison for that offense in 2021. Shortly after being placed on parole and being released from prison in that case, he committed another felony offense of attempted robbery and disrupting public service. He was sentenced to prison in that case in 2023. Then he was released in that case in May of 2025. The defendant committed 2 misdemeanor crimes before committing this one. He was out on bail, at least in one case when this offense was committed. The defendant has not responded favorably to any of those prison sentences, but additionally he hasn't responded favorably to the community control sanctions that were placed on him in the municipal court for those misdemeanors, which he's received convictions for as well. There is a pattern of alcohol use related to this offense. The defendant has not, despite court orders, it's my understanding, again from the municipal court, followed through with getting the treatment that has been court ordered. All this shows that he is not an appropriate candidate for community control.
Thank you. As for factors indicating recidivism is more serious, almost all of these are present. The defendant committed the offense while he was on bond. He has a very lengthy history of juvenile delinquency adjudications and criminal convictions as an adult. I mean, the defendant's only 29 years old, and his criminal history goes back 18 years. Started when he was 12 years old. Lengthy juvenile history, and just continued on as an adult. Drug abuse and or alcohol problem related to the offense, and he hasn't done anything to deal with it. In this particular case, he got out of prison in May. Within 3 months, he's back committing crimes. Committed 2 misdemeanor offenses, and then this. 3 months. He says that he wants all this help, but he hasn't done anything to get it. Until crimes are committed and he's facing court for sentencing. He's put on probation for one of these misdemeanors, and he violated already. Because he didn't do anything he was supposed to do. It's the same thing over and over and over. And I hear the same things. So I read and looked at the prior pre-sentence reports that I have, and you say the same thing. I want to get help. I need to get some drug or alcohol help. I need to get mental health help. And you don't do it. So you've said this stuff before. There are factors indicate recidivism is more likely. There's nothing indicating it's less likely. In 2913B1, defendants previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's just no way this court can make a finding defendants amenable to available community control sanctions.
And that's the final ruling, 24 months in prison. Even though the defense pushed for treatment and probation, the judge focused on the long history of offenses and repeated chances that didn't stick. But here's a question for you. Should courts prioritize rehabilitation for addiction-related crimes, Or does a long criminal record make prison the only option? Let me know what you think in the comments.
Therefore, it's the sentence of this court that on count 1, defendant served a term in prison of 24 months. On count 2, he served a term in prison of 8 months. Those will be served concurrent with each other for a 24-month prison term. Has credit for 4 days that he served on this case. Any other time that was in the jail, he was serving his sentence for the misdemeanor offenses that he was convicted of.